A pleasant day to everyone, especially to Attorney Beverly Burkau. Today, I will going to report the Section 23 of Rule 119, or what we call the demurrer to evidence. So, before I recite or explain the Section 23 of Rule 119, first, I will define what is demurrer to evidence. So, when we say demurrer to evidence, it is when someone in a court case says that the evidence presented is not enough to prove their case. So, in short, it is also known as insufficiency of evidence. For the first paragraph, after the prosecution rests its case, the court may dismiss the action on the ground of insufficiency of evidence. First, on its own initiative after giving the prosecution the opportunity to be heard, or upon the demurrer to evidence filed by the accused with or without leave of court. In Section 23, it states that the court will allow the prosecution have all the opportunities to present its case in order not to be dismissed. So, the court can decide to dismiss the case due to lack of evidence, either on motion or in response to a demurrer to evidence that the accused had filed, even if in that demurrer to evidence, the judge or court grants the permission or not. So remember that the demurrer to evidence is filed by the accused. Second paragraph, if the court denies the demurrer to evidence filed with leave of court, the accused may adduce evidence in his defense. So when we say leave of court, it means with the permission of the court. So if the court gave its blessings or approval to file the demurrer to evidence, the accused is allowed to show evidence as his defense. Yet, the next sentence says, but if our demurrer to evidence don't have permission of the court, then our client or the accused has no right to present his evidence, and automatically, we are submitting the case for judgment on the basis of the evidence for the prosecution. So why does it will be automatically we are submitting the case for judgment on the basis of the evidence for the prosecution if our demurrer to evidence was not allowed or was permitted by the court? It is because a demurrer to evidence is a matter of discretion on the part of the court rather than a right. So the court's permission must be acquired first before it is filed, or else the accused would lose certain privileges. So now let's go to the third paragraph. So how do we file a demurrer to evidence? So within non-extendable period of 5 days after the prosecution rests, the accused should file a motion for leave of court, or what we call you're asking permission to file a demurrer to evidence stating its ground or reasons. So the prosecution is also given a non-extendable period of 5 days upon its receipt to oppose or object or rebut the motion that the accused filed. If the motion is granted, the accused shall file the demurrer to evidence within non-extendable period of 10 days from notice of grant of leave of court. And the prosecution can oppose the same or the demurrer to evidence within non-extendable period of 10 days also from its receipt of the demurrer. So again, the accused only have non-extendable 5 days to file a motion. Then the prosecution can oppose the file motion of the accused within non-extendable 5 days also. So then if the motion is granted by the court, the accused shall file the demurrer to evidence within an extendable of 10 days. Then the prosecution can oppose the said motion within non-extendable period of 10 days also from the receipt of the demurrer. So when we say certiorari, it means a writ where a higher court, such as an appellate court, can review the lower court's decision. The denial of the demurrer to evidence cannot be appealed or certiorari granted since it is a temporary order that does not pass judgment on the grounds of the case. So now, let's move on. Let's go to the section 24 of Rule 119 or the reopening. At any time before finality of the judgment of conviction, the judge may motu proprio or upon motion with hearing in either case, reopen the proceeding to avoid miscarriage of justice. The proceedings shall be terminated within 30 days from the order granting it. After trial, where the accused and plaintiff present their evidences and defenses, the judge says it's time for submitted of decision. While waiting for the decision of the judge and you have newly discovered evidence, you can now apply for motion to reopen. Either the accused or the complainant can file a motion to reopen. This can be also initiated by the judge himself. There will be a hearing typically conducted in order to know the reasons for reopening the case. Once the decision is made to reopen, the proceedings must be completed within 30 days from order granting it to ensure a swift resolution. This provision is conducted and it aims to prevent wrongful convictions or other miscarriages of justice by providing timely method for resolving potential errors or injustices in the legal processes. So that's all for my report. Again, I am Jassel Rafael, and I would like to say thank you for listening this video. God bless.